Good afternoon and welcome. This is the Tenancy Relief Package webcast presented by Australian Business Lawyers and Advisors. I'm Iain Rennie and I'll moderate the session. With me in Sydney is my colleague Warwick LaHood. Warwick is a director and head of our property team. And in Melbourne, Jane Wolfe. Jane is an associate director in the property team. Both Jane and Warwick have many years of experience in property law. They are expert in leasing and they have followed the debate and evolution of the relief package. What we'll try to get through today will be a history of the relief package and the role of the National Cabinet. What is the code and how is it implemented? A discussion of the key elements of the code, and then a discussion on the first legislative response of the first state in Australia to act on it, New South Wales. We'll then look at how certain other third parties play a role in the implementation of the code, and then we'll talk generally about how stakeholders should deal with problems coming under the code, or if in New South Wales, under the New South Wales Regulation. We'll start with an overview. As we all know, there's been a furious amount of activity to deal with the pandemic. We've had both job seekers, job keepers, and the relief package. Put in context, the relief package was announced first, but it took a while to come into play. In contrast, job keepers has vaulted over the top. It's been the subject of federal legislation and a long set of rules from the Treasurer. But in the case of the tenancy relief package, we've had not so much activity. When the Prime Minister stood after the National Cabinet on a Friday in early April, he released the National Cabinet Mandatory Code of Conduct. In that document, it expressed its purpose as to set out good faith leasing principles and said that the spirit of all leasing arrangements should be determined pursuant to those principles. So, if I may turn to Jane, after 3 weeks, does the expectations match the reality?
In one word, no, not really. So we've got this national code that hasn't yet been implemented. It's left to the states and territories to implement it, and with the exception of New South Wales, nobody has yet done so. So we're still acting on a set of principles and spirit of the code.
I remember that the Prime Minister also said that the code would in fact evidence a uniform national code. Are we going to get that, or what is going to roll out from here on? Do we know?
We don't know. We can see what's happened in New South Wales. I suspect that what comes out of the other states and territories will look relatively similar, but may be very different. We just don't know until we see what comes out.
So let's have a look at the code itself and the National Cabinet. Jane, take us through this one.
Okay, so the National Cabinet is made up of the Prime Minister, the state and territory premiers, their chief ministers and the chief health officers. And it was established to provide a general forum for national joint leadership, so to cover everything to do with the pandemic.
So Jane, take us through the code, its history and some of its foundational elements.
Okay, so the code is a statement of principles, so it's not law yet until it's enacted by the various states and territories. It's intended to create a national response that is consistent to commercial leasing issues during the COVID-19 pandemic. Basically, it creates a set of good faith leasing principles for commercial tenancies, which includes retail, office and industrial, and imposes those principles to the negotiation of amendments to existing lease arrangements between landlords and tenants. And as I said, it's a code, not a law. So at the moment, it's just principles to be acted on, apart from New South Wales, where they have actually enacted a regulation covering some of the topics expressed in the code.
So the code becomes law when the states and territories individually respond to and adopt it.
That's right. That's right. There's nothing what the code itself says, there's nothing to stop landlords and tenants negotiating under the principles of the code before anything is legislated, but only in New South Wales have they actual legislation on it.
Let's go on.
And it's got principles, things like landlords can't terminate your lease for non-payment of rent. They should waive other expenses and outgoings if possible. They should pass on concessions that they receive, say deferral of mortgage payments or land tax concessions, that kind of thing.
So to whom does it apply? Does it apply to all commercial leases or not?
No, it applies to tenants who have a turnover of less than 50 million for the 2018-19 financial year, and also are eligible for JobKeeper. And the eligibility for JobKeeper, very basic, is a more than 30% reduction in turnover due to the COVID-19 pandemic.
So franchisees, group companies?
Franchisees, the test is on the individual franchises, and with group companies, it is the group as a whole, so the revenue for the group as a whole.
So what about residential? Where does that fit?
Warwick, I might give you that one.
Oh, thanks, Jane. Under the New South Wales situation, New South Wales has passed a regulation to govern residential tenancies during the pandemic. The code itself does not refer to residential. It isn't about residential. The code is about commercial tenancies. But New South Wales has passed a regulation for residential tenancies, primarily adopting the principles that are under the code. And there are 14 principles under the code. The main aspect about the residential tenancy regulation in New South Wales, which started on mid-April, 15 April, is about restraining landlords from terminating a residential tenancy if they're an impacted tenant. And then the regulations define an impacted tenant in similar ways to the way the commercial tenancies are defined under the code.
So let's go back to the National Cabinet and its code and its focus on commercial leases. We've moved on now to a slide which, identifies the fact that the code sees a role for third parties. Jane, this was your one again, and this is curious.
Yeah.
So we have the code, which is not law, but we also have a code which is calling for contributions from third parties. Talk us through this, please.
The code expresses an expectation that the banks, for example, will have a role to play in supporting landlords and tenants in reaching their agreements. So presumably to defer mortgages, for example, with landlords. Otherwise, there's not much in the code apart from that expectation on the banks, and there is not obligations, but a principle that landlords will pass on any concessions they receive to their tenants. And then we've heard different responses from the banks with their stimulus packages, government stimulus packages, the ACCC jumping in with their temporary authorisation for retailers to collectively bargain. But none of it ties into the code. And the New South Wales Code, for example, makes no mention of the banks. So that principle of expectation on the banks to come to the party has sort of not really come to anything yet.
So an expectation presumably is not enforceable. This is, again, just the National Cabinet expressing a view.
Yeah.
And then with
exactly.
the big four banks, I think as far as we know, that's an individual response from each of the banks.
Yes, that's right. It's an individual response. One can expect, you'd think the big four banks would join in on the purposes of the code and have a good look at the principles of the code to see how they can make decisions to help landlords and tenants achieve variations to their leases in some way to adopt the code's principles. One would think that.
I think it's...
Yeah, although the bank stimulus packages came out before the code was announced. So whether or not they've had a look at the code since and
yes,
tried to work around those principles, I don't know.
The thing that grabs my attention, though, is the ACCC and its interim authorisation. That's effectively a permission for collective bargaining, so it would be collective behaviour which would otherwise be prohibited.
That's right. I mean, that's a positive for tenants, especially tenants in shopping centres.
Yeah, it's certainly a positive for small tenants in shopping centres who would normally have very little bargaining power.
Yep.
Warwick,
yes.
Over to you. Principles under the code.
Yeah. One of the critical aspects that tenants and landlords should be aware of are what are the principles under the code. There are 14 of them, 14, and it's important to know what the principles are saying and how you interpret them. It's critical because of the way the principles have been adopted in New South Wales, and one can expect possibly other states to do a very similar thing in terms of adopting the principles under the code. There are 14 principles. One principle, which is a considerable one, is the landlords can't terminate leases due to non-payment of rent during the pandemic period. I'd ask everyone to download a copy of the code. We give a link to that at the end of this webcast, but download and have a look at them. They're not that hard to understand, and putting them in context for your particular situation, whether you're landlord or tenant. Some other parts of the principles are about rent reduction. The principles talk about reducing rent. Now, the manner in which the code sets down a principle to reduce rent is based on the proportional disruption to your trade. So if you've had a disruption of 50% to your trade, then the principles say that your rent should reduce by 50%. Now, of that reduction, the principles are saying half of it should go to deferral and half of it should go to waiver. We've had a lot of questions since the code's come down as to what's deferral, what's waiver. A waiver is where you don't have to pay the rent. An abatement, that's what a waiver is. A deferral is just that whatever amount is deferred to another day for that tenant to pay. Now, under the principles, the idea is to defer it so you can pay it off for the balance of the lease term, or 24 months, whichever's the greater. And parties can agree otherwise depending on the financial circumstances of the landlord and the financial circumstances of the tenant. So that's the difference between deferral and waiver. It's a principle. Of course, parties can agree to something else.
Warwick, can I just take up, that's all tenant facing.
Yes.
What about for the landlord? Is there anything in the code which is landlord facing?
Well, the code is centred around tenant relief.
Right.
The code does say, though, that parties must act in good faith. That's a principle.
We'll get onto that in a minute.
Yeah.
Same thing. But I'm curious to see whether the landlord actually has any specifics it can rely upon in the code.
The landlord can rely upon if a tenant fails to abide by their obligations during the pandemic period. If a landlord and tenant have come to an agreement to deal with this pandemic and the tenant fails to abide by that, the tenant loses protections as the code allows them, if the code's adopted. The landlord also has other protections through third-party relief. Things like land tax, relief from banks and financial institutions. They're all principles under the code. So the landlord can turn to third parties to get some form of relief from their side.
So can we just take a step back?
Yeah.
There was general discussion amongst some states about state tax relief. Has there been any formal announcements on state tax relief at all?
There's been no formal announcement on state tax relief, although one would expect that there will be, and will be soon, as to the exact amount of tax relief landlords will get, whether that's in the form of a waiver of land tax or a deferral of land tax.
Or I think I've heard rebates in New South Wales.
Or rebates possibly given back to landlords who've already paid land tax. But at this stage, we don't know the detail of what relief will be given to landlords, but we do know that we'd expect the state government to give some form of relief. Now, if a landlord does get that relief, and under the lease, the tenant pays the land tax of the landlord, they've got to pass that on. You'd expect that to be passed on to a tenant.
But it is curious, again, because we've got a national code which only grabs enforceability when it's adopted by the states, and we have states talking about ancillary benefits, but we actually haven't got anything of substance to rely upon.
Other than New South Wales, we've got no substance. A discussion and looking at the code is just that, a code of conduct. And you heard before, it isn't binding on parties. It sets out a set of principles for parties to look at, to negotiate, to vary their leases. We've only got New South Wales who have adopted the code, and they haven't adopted it in full, but they have made reference to the principles.
So let's move on, and we'll look at two of the big issues coming out of the code. Good faith, and that seems to be the very cornerstone of everything. And then what happens when negotiations fail? So Warwick, good faith, what is it?
Yeah. Good faith, it's important, I feel, for tenants and landlords to understand what does good faith mean in negotiations, because you're used to negotiating a lease to see what is best for you as a landlord or as a tenant. When it comes to good faith, the principles require that parties must negotiate in good faith. What's the common purpose? You've got to sit there as a landlord and look at the tenant's financial situation. And as a tenant, you've got to look at the landlord's financial information and say, well, this landlord's under financial stress. What does it take for this landlord to get through this pandemic? What does it take this tenant to get through the pandemic? Not what's best for me, but what's best for both of us to address this common enemy, this pandemic. And that's what I'd like parties to consider, a common purpose to get through this pandemic, to be open about your financials and to be truthful, of course, but open.
So is there a definition that can aid people at all?
The courts over hundreds of years have discussed the concepts of good faith. And I could take you through technicalities of how the courts see good faith. What I can say is that in this code, the code's adopted principles which start to define what good faith is. And it's starting to narrow down your considerations and how open you must be with the other side. So I'd ask people to really...
Sorry, Jane?
If I just step in there, and the definition that I read for good faith was broken into two parts, and one was to act honestly and not arbitrarily, and the other was to act reasonably with regard to the interests of the other party without any obligation for you to subordinate your own interests. So it's about working out the best thing that suits everybody. It may not be exactly what you want, maybe not exactly what the landlord wants or the tenant wants, but you need to come to some mutually agreeable position.
Yeah, well, that's right. I mean, you've got to look at the other side, you've got to look at the common purpose.
But how do you prove?
It's all about achieving the principles of the code.
But again, I mean, this is the point. If we go through ordinarily black and white law and where we're procedurally driven, how does somebody prove or establish they've acted with good faith?
Well, that's a difficulty. I think you've got to look at your 14 principles under the code and see if the other party has addressed those. If you get a party that just simply says no to everything and refuses to disclose financials or tell the other party how they're affected, that's not good faith. Good faith is being honest with each other about how the pandemic has affected your financial bottom line and about your own gearing. Right. So it's that honesty.
Yeah.
Well, I find this really tough. I understand it's an expression of intent, but how do we organise people to do this? What is it? I suppose we've got the hallmark that they've got to be job keepers eligible.
That's right.
So they need to have gathered together as a tenant the information which will show financial affect from job keepers.
That's right.
But is there any hints you can give as to how me, for example, as a tenant, would approach a negotiation with a landlord, and how would I start it off in good faith?
Well, there's always an opportunity for tenants to call upon their landlord and the agent to come to the table to renegotiate, just to renegotiate a variation to your lease for a short period during the pandemic period. And it's just simply calling for the landlord. And we say later on what you should do now, whether you're in New South Wales or any other state that hasn't regulated the code or part of the code, we talk about what you should do.
Okay, let's move on. Jane, what happens if negotiations drag on or become frustrated? What does the code suggest we do?
Okay, well, the code says that we go to the relevant state or territory dispute resolution process for retail and commercial leases.
Yeah. In New South Wales, that's the to start the mediation process. It's the Small Business Commissioner. I expect that in other states as well.
But again, if we go back to first principles, I think there's a call to go first to mediation.
Yes.
There's no one meaning of mediation.
Yes, there is.
There's no universal set of rules. There's no determination as to the quality or experience of a mediator. So I take the code says you go to mediation by whatever rules. Then what happens?
Well, the code proposes mediation and dispute resolution under the states and territories.
Move on.
And one of the principles of the code is that parties shouldn't use that process to delay or frustrate amicable resolutions that they could come to themselves. Generally, so under the New South Wales sets it out, what you do and how it works. But everywhere else, again, it's just a principle of mediation under usually the Office of Small Business.
But again, I'm trying to tease this out. I mean, if you have a 6-month or 9-month period that is facing us now, you commence your negotiations, it becomes frustrated, you go to mediation, and mediation by definition is an attempt by a third party to bring you to agreement. But what happens if you don't come to agreement? What happens after that? And all the time your 6 or 9 months is ticking down during this period. Where do you go after that?
And if you don't come to agreement, you would go to the NCAT in New South Wales, VCAT, Victoria, other relevant bodies in other states. But you're right, there are no time limits.
And are there any penalties for somebody frustrating the process? Is there a financial penalty, for example?
No, there's no financial penalty.
There's no financial.
What there is, though, is when we move to the New South Wales regulations, is a restraint on the landlords if they haven't followed this good faith mediation process.
We'll come to that, because that's the New South Wales response, and that's an important one.
Oh, that's the response on the code too.
Okay.
Yeah.
Okay. All right, let's move on. So, with great surprise, New South Wales released its regulation last Friday. It's fair to say that if we presented to you the slides that were available last Friday, they'd be quite different. We didn't have one response from the state or territory, but we now do.
Move the slide.
So, Jane, take us through the New South Wales response.
Okay, so the New South Wales response is done by amendments to the Retail Leases Act and the Conveyancing Act so that it covers retail leases and pretty much all commercial and industrial leases. It runs for a period of 6 months from the 24th of April, so until the 24th of October, which is when it is repealed. It works through concepts of impacted lessee, which fits in with the principle of the code, which was the turnover of less than 50 million and eligible for JobKeeper. And it acts to prohibit and regulate the exercise of landlords' rights relating to the enforcement of leases during that 6-month period.
So, unlike the code, is the regulation enforceable?
Yes. It's enforceable in that landlords can't take certain prescribed actions under the lease until they go through the process set out in the regulation, which follows the principles of the code. Not all of the principles of the code are included, and not all leases are included. So, for example, a lease entered into after 24 April, unless it's an option to renew, won't be covered. And it also doesn't cover leases under the Agricultural Tenancies Act.
Residential, again, I presume is excluded from this package?
Yes.
But
yes.
there is the New South Wales...
The residential's already taken care of. So they've enacted legislation for residential. And but this now covers commercial leases right from retail, industrial and commercial if they fall under the definitions of the regulation.
Yeah, and it requires landlords and tenants to renegotiate the rent and other terms of their lease in good faith and following the principles of the code.
So there was an issue that arose. There's an issue that arose amongst us over the weekend, which was whether the New South Wales regulation has retrospective effect or not.
Yes, this is a bit tricky, but the regulation commenced last Friday. It goes for 6 months. It applies to impacted tenants. Now, impacted tenants, as per the code, where the turnover is less than 50 million, and you qualify for the JobKeeper scheme. So if you're an impacted lessee, these regulations will apply to the lease. Now, the prescribed period, which you've said before, is 6 months after the regulations commenced. So, in a sense, there is retrospective application to the extent that you fall under the JobKeeper program. Now...
And also because the regulations, they act to prevent a landlord from taking action, but also from continuing any action. So, for example, if a landlord had started an action prior to the 24th of April.
So let's have a look at that. I think that's the prescribed actions. Warwick?
Yep, some of these
how do these work? Sorry, how do they work?
Under the regulation, there are certain actions that are called prescribed actions that cannot be taken by a landlord unless good faith negotiations have been exhausted as required by the regulation. Now, here are some prescribed actions on the screen now. Have a look at them. They will generally apply to most tenancies. A landlord can't do any of those things during the pandemic period. They can do those things if they've followed the dispute resolution procedure under the regulation, which requires the good faith negotiations. And
Can I just jump in there? Those prescribed actions can't be taken in certain circumstances. So it's not in all circumstances. It's for failure, a breach for failure to pay rent, breach for failure to pay outgoings, or the business operating under the lease not being open for the hours that it's supposed to be open under the lease.
But nonetheless, that's quite a list of prohibitions.
Oh, there are. If you read the regulation, and we ask people to read the regulation as well, to look at the type of things that can't be done during the prescribed period.
So again, it's not the case that they can't be done at all. It's that they cannot be done unless you have followed the procedure under the regulation.
That's right. There's a procedure, and that starts with the call for renegotiations by one party on the other. So there must be a call for negotiations.
So let's look at the...
So the obligation is on landlords really to comply with the requirement to renegotiate before they can take any prescribed action.
But then let's look at the very last point on that slide, existing enforcement actions. So if we have a lease which is caught, we have a dispute between landlord and tenant, and there's some form of enforcement action perhaps commenced a month ago, 2 months ago.
Yeah.
What does the New South Wales regulation do to that?
The regulation seems to apply to existing enforcement actions because under the regulation it talks about continuing to take enforcement action. So a landlord can't continue to take that action unless it goes through that dispute resolution procedures that the regulations impose on everyone. So currently, if you do have a dispute, you should be calling for those negotiations to take place.
So until such time as the negotiations have run their course and maybe dispute resolution, the landlord cannot
continue that action.
Or continue an existing action.
That's right. And mediation is not the mediation you may have already tried with the landlord. Now it's mediation to take into account the COVID-19 principles in the code. So they now must be considered as part of a mediation.
Let's have a look at the next slide. Again, so this is from a different perspective. We've got the prior slide was really looking at prohibitions on landlords, what they can do. But here we have relief against forfeiture, a tenant's right. How does that fit into the regulation?
Thanks, Iain. This is an existing right of a tenant to seek relief against forfeiture or attempts to forfeit a lease by a landlord. Tenants already have this right. It primarily sits under Section 129 of the Conveyancing Act. So a tenant has the right to approach the court to seek relief, even if they've breached the lease. The regulations that have been put in place for New South Wales actually empowers Section 129 and says that if there are current actions in place, that the court can take into account the effects, the leasing principles under the code, the effects of the pandemic, if granting relief. So that action's in place. That right's in place. It's been enhanced by the regulations by telling the court that you must take into account the code, the leasing principles under the code.
So if we just go back to the previous slide, so that's quite a stark contrast. So the prescribed actions are effectively prohibitions on landlords and what they can do without having first complied with the code. And then we have, by virtue of its drafting, the New South Wales regulation retains and entrenches the right against forfeiture.
That's right. And now adds that consideration for the court to consider. The pandemic response.
Yeah,
whether to give a tenant relief against a forfeiture of the lease. So that's important to understand. Hopefully, though, both parties will see that negotiations, in good faith, will come to a reasonable solution during the pandemic period to vary the lease.
So where we're coming to is a point where we have the national response being the code, being largely just a statement of principles and really not enforceable, with one exception being New South Wales, which has now adopted its own very specific regulation and created a series of prohibitions and entrenchments. It's a very strange position for the nation to be in.
It is, Iain. One thing that we're getting a lot of questions on is, can I demand rent relief, etc.? Just on a general basis, the code has principles that says that a tenant will be given rent relief by looking at the proportional disruption of your trade. That hasn't been regulated. That's not a regulation. So it hasn't been adopted. That principle has not been adopted by the New South Wales government. So you can't force a landlord to reduce your rent. What you can say is that that parties have got to negotiate based on the principles. So it's only a principle. It's only a principle.
Okay, let's move on. What next? So this slide's supposed to be addressing the strange situation we're in.
It does.
If you're outside of New South Wales, what do you do?
Well, whether you're outside or inside New South Wales at the moment, one thing you should be looking at in terms of landlord and tenant is start preparing your financials. You're probably sitting out there thinking, what's happened? We thought the code was in place. I've received many calls about people not paying rent because they thought the code was law. And then when you try and explain, no, the code wasn't law a week ago, the tenant realises they've breached their lease. The code is regulated in New South Wales only. It doesn't matter that it's only been regulated in New South Wales. What tenants and landlords should be doing is getting some legal and accounting advice on the application of the code in their state and looking at the regulations in New South Wales and how that mixes together to give parties rights and obligations. What does good faith mean? They should also be getting some accounting advice and financial advice on how this pandemic's affected them. Now, there'll be some businesses where it's clearly 100%. The government's given a directive, close down. That's 100%, that's pretty obvious. But there are some cases where it isn't so obvious. I had one office ring me up and say, we don't need the space anymore because we can work from home, therefore we're going to rely on the code. Their income didn't change, it went up. That doesn't apply to them. In terms of accounting advice, it's not that easy. Even restaurants are still doing takeaways. You've got to look at that proportionality principle. Start gathering your financial information to show the other party how you've been affected by this pandemic. Start thinking with your advisors. What is an affordable solution?
Affordable to whom?
Affordable to both landlord and tenant. Some landlords will be under stress through mortgages. They may have mortgaged across their portfolio. and they might be limited as to how much they can give. Those landlords should be looking at what relief they can get beyond from the tenant. Look at what government's going to give them. See what's affordable for the landlord during the pandemic period. It's creating affordable certainty for the parties. And tenants likewise. They need to work out what can we afford. Have a look at your landlord. And if your landlord's heavily geared, try and work out an affordable solution that suits both parties.
So I sort of try and draw some things together.
Finally, sorry, Iain.
Yeah.
Finally, you call for negotiations.
Yep.
Because the regulation makes it very clear you've got to call for negotiations.
Well, procedure is your friend.
Procedure is your friend.
Yep.
Yeah.
But I just want to, and Jane, maybe I'll ask you this, but so we seem to be in the situation that we don't have a uniform national response. We have a code which is expressed as a guideline, I presume, at its strongest. Even it excludes, well, it expressly excludes residential. It excludes a whole lot of commercial leases where one party is just too large and they just have to look after themselves. And then we have, as a specific example, we have New South Wales at the moment, which has more or less adopted but varied or applied in its own context the code by creating an enforceable regulation. Is that where we're at now?
That's pretty much exactly where we're at. So the code is what it is, which is a statement of principles. It does expect the larger landlords and tenants who don't necessarily fit under the code to also follow the spirit of the code in their negotiations. But again, that's just expressed as an expectation. So I think in New South Wales, they've got something. Everywhere else, there's nothing yet, except the principles. But I would say that landlords and tenants really get ready, the same as Warwick has just said they should get ready in New South Wales, getting their financials together and instigating conversations with each other, understanding what each other need and want.
Yeah, Iain, Jane, I think we can expect the other states to follow fairly soon. Now that New South Wales has passed this regulation, one would expect the other states to pretty much follow that. Well, you'd hope they would, to create some certainty across the nation. But even as we said, even though the regulation's passed, it doesn't fully adopt the code. Not fully. It puts restraints on landlords, it puts restraints on tenants. But understanding the principles of the code is very important, because I think every state will require good faith negotiations taking into account the principles of the code. So it's important to understand that and get legal advice on it.
They will follow certain things. Everybody will be the same, I imagine, such as the threshold tests.
Yes.
For whether you're an eligible tenant.
And
what the other states and territories do, well, I think it's going to look similar to New South Wales, and they may add in some more stuff.
Yeah.
And do you think the enforcement part works in New South Wales?
The enforcement is merely, from what we can see, a restraint. Tenant
it's
can't...
not really enforcement.
Yes, it's just restraining the landlord. Where there's a lot of uncertainty. It only came in last Friday. There's still a little bit of uncertainty on how the regulation operates. If the parties can't come to an agreement, what happens there?
So is there a time, I'm just trying to pick up and trying to get some certainty. If I'm a tenant and I take your advice and I approach my landlord and I either get no response or I get involved in a very turgid series of engagements and 3 months down the way I'm no further along, what do I do? How do I get my position clarified and things resolved?
Well, this is one of the problems. Certainly in that situation, a landlord couldn't take enforcement action.
Yep.
If a tenant's not prepared to negotiate, what does a landlord do? The tenant may not get the protections under the regulation if they don't turn up and at least try and negotiate.
Well, that's right, because refusing to negotiate isn't good faith.
That's right. Refusing to negotiate is not good faith, almost bad faith.
But I think the issue is that there is no enforcement. There's a restraint. so they can't evict, a landlord can't evict a tenant. But as to what happens afterwards, what happens if the pandemic comes to an end and I haven't been evicted but I owe however many months' rent?
Is it possible for people to go around the code? For example, they enter into good faith negotiations and they deal with matters which are just outside of the principles of the code. Is that okay?
Yes, yes. In fact, that's something that Jane and I have tried to get people to do, encourage people, is to look at what you can afford, identify a solution, and if you and the landlord, if the tenant and the landlord can come to an agreement on that solution, whether it's within or outside the code, it's affordable for both parties, put it in place. It gives you affordable certainty.
They can also agree, for example, that the landlord can take some prescribed actions.
Mm-hmm.
They can agree to terminate the lease between them.
Yeah.
So there's nothing stopping anyone from coming to their own solution outside the code.
Yeah.
Actually, can we just jump into the Q&A?
Yeah.
There's a series of things which get teased out in the Q&As. So these questions came to us over the last few days. Questions are coming in now, so we'll get through as many as we can. First question, Warwick,
yes,
it's for you. If my lease is expiring and I'm offered a new lease, is that new lease covered by the New South Wales regulation?
Yes, Iain, I saw a lot of those questions come through. The regulation applies to existing leases up to the date it commenced, last Friday. It doesn't apply to new leases that are entered into after Friday. However, it still applies if you renew your option to an existing lease that existed before last Friday, or if you're looking to extend the existing lease. I've heard of one circumstance where the landlord offered the existing tenant a whole new lease. Rather than extend the existing, they offered a new lease. Now that could be considered a new lease that may not fall under the regulation because it's new, as opposed to extending an existing lease or renewing an existing lease. So just be aware that leases entered into after last Friday do not fall under this code or the regulation. They're not protected. Only ones that existed last Friday or were existing ones that were extended or renewed.
Jane?
And yeah, I think in that circumstance you would be advised to make a variation to your existing lease, not to enter into a new lease.
That's for a tenant anyway.
So Jane, one for you. Are licences considered leases under the New South Wales regulation?
There's no mention of licences. However, I suspect that the answer to that is yes.
Yeah.
Licences will be covered and probably under the Conveyancing Act.
Yeah, I somewhat agree.
And all the retail leases.
And all the retail leases. Look, licences are normally short-term agreements to occupy space. They are most likely covered. Whether a short-term agreement is naturally extended by the regulations, I don't think they are. If you've got a short-term lease in place that only goes for the next few months, I don't believe the regulations will increase that tenure of the lease.
So on the same theme, what if we have this conversation in 2 months' time and a lease has expired? So it was there at the relevant time, but it's expired. Does the New South Wales regulation, or in fact the code, deal with an expired lease?
It certainly does. It's still covered by the code, but whether it enables or restrains a landlord from terminating the lease on a month-to-month notice, which a landlord can do normally in an expired lease, I don't believe the regulations will restrain the landlord from terminating a month-to-month lease.
Okay, I want to put two questions together.
The other issue with an expired lease, is that if you have come to an arrangement with the landlord as a tenant to defer your rent, what happens to that deferred rent? Because normally it would be repaid over a period of time following lease expiry. If your lease expires in the middle of the pandemic, where does the deferred rent go?
Yeah, Jane, that's a good point. The code sets down when a principle on how deferred rent is going to be paid. That hasn't been regulated. So you can't enforce that against the landlord, or you can't enforce it against the tenant. So when it comes to deferral of rent, that's a matter of negotiations. The code sets down the principle that it's to be paid over the balance of the term of the lease or 24 months.
That's right. So in the case of an expired lease, you would need to come to some separate arrangement, particularly if you're a landlord, to cover how that deferred rent is going to be repaid to you later on.
Okay, Jane, I've got a couple of questions which I'll try and put together. They're all about the upfront negotiation. Is there any prescription or guidance as to an entitlement to a deduction? Sorry, to a reduction? For example, people have asked whether they're entitled to 50% or 30%, depending upon their financial circumstances at the moment. So do we have any guidance under the regulation or the code as to where you may put yourself along a spectrum?
There is some guidance under the code, and it's all about proportionality. So proportionate to your reduction in turnover. The regulation doesn't appear to say anything about it at all.
Yeah, so it doesn't adopt the principle. So it becomes a principle. So it's the code that's a leasing principle to take into account when you're entering good faith negotiations. It isn't something that you can force a landlord to give you a rent reduction. It's a principle.
So there's no formula?
No. Mind you, if a party simply denies a rent reduction for no good reason, then that might not be seen as good faith, noting that it is a principle in the code.
Okay, Warwick.
Yeah, I think they put a formula of sorts which says up to 100%, but it's proportionate.
Warwick, two questions I'll try and put together. I'll read the first one. I've asked my landlord for some sort of discount on my rent or lease, but he is not agreeable to this. Is there anything that can help tenants get some form of discounts? This is a childcare centre, and so it's a commercial lease. So I would interpret that as perhaps a good faith issue. And here's the second question. What to do if the property manager and landlord are playing hardball and not willing to start a dialogue and communicate?
Yes, this is where I certainly take the view that if an agent or landlord are playing hardball, which you'd expect in commercial negotiations and things like that, these are not commercial negotiations, these are good faith negotiations. And if the landlord or the agent are simply denying any rent reduction for no reason whatsoever, they're not following the principles of the code. That's not following the principles of the code. That, to me, is not good faith negotiations. If that's right, which I think it would be, if that's not good faith negotiations, they therefore cannot take on a prescribed action. So,
in New South Wales?
In New South Wales. Well, we don't know the other states yet, but you hopefully expect the other states to follow that concept.
Jane, for you, is there a time frame mandated or proposed for negotiations?
No, there isn't. So you can negotiate for as long as you like, I assume, and then if negotiations fail, go to mediation and through the dispute resolution process. So no time frame.
Jane, do you think if a landlord calls for a tenant to renegotiate, or the other way around, and the other party doesn't respond for months, that's almost bad faith, that's not good faith?
Yeah, I agree. Refusing to negotiate is not good faith.
Yeah.
Question for Warwick.
Yeah.
What is reasonable for commercial tenants to request from their landlords, and what alternatives do they have if the landlord is not agreeable to it? Now, can I just rephrase that from one perspective, which is it by definition bad faith if your landlord does not agree with your proposed rent reduction?
I wouldn't say it's necessarily bad faith. It doesn't follow, because the landlord might be in a position they can't offer a rent reduction.
Yep.
But the landlord's got to give that information to the tenant, as does the tenant need to give it to the landlord. So what is good faith is giving each other a complete an open view of each other's financials and how this pandemic's affected each other, and then trying to come to a common purpose to see if a solution can can be determined or resolved. That's good faith negotiation.
So this is the affordable solution.
The affordable solution for both parties. The affordable solution. Affordable certainty.
Jane, for you, can commercial agreements between landlords and tenants be agreed upon other than those outlined in the code? I think you've touched on that. What powers does a landlord have if a tenant does not abide by the new agreement made?
Okay, so the principles of the code say that a tenant must abide by any agreed amendments to the lease. So you've got to, if you're a tenant, you need to comply with the lease as amended by agreement between you. And if you don't, you'll lose protection of the code if you're following the code, and you'll lose protection generally.
And that's one reason why tenants and landlords should get that legal, accounting and financial advice to make sure when they're negotiating that they can negotiate on terms that's going to see them through the pandemic and not halfway
and
through.
Also, if they find themselves in a position where they're thinking, I can't comply with this, they need to go back to the landlord straight away and start a new dialogue.
So how does it work with the varied lease and the prescribed actions?
Yes, well, everyone should have a lease agreement and it should be in writing. And most lease agreements all lease agreements more than 3 years in New South Wales must be registered. And the way that technically that's going to be managed, parties will get together, hopefully come to a solution to vary the lease. That variation must be in writing. It must be documented in writing. Don't leave it to oral discussions, because oral discussions can be interpreted. Put it in writing and make sure that writing is certain. It can't be misinterpreted.
So if you...
By way of a deed.
If you've resolved matters between landlord and tenant and they're dealing with some matters which are outside of the code, for example, and then subsequent to that, a tenant breaches those provisions, in New South Wales, does the landlord have to be aware of the prescribed actions, or is this outside of the... No,
they still need to be aware of the prescribed actions. So if you've come to an agreement between you, you're still an impacted lessee for the purposes of the regulations. Well, you'll always be an impacted lessee.
So you then need to go back through the good faith.
You might need to go back through the good faith. But it's making sure the solution...
The principles of the code do say that if a tenant reaches agreement with its landlord and then breaches
they lose the protection.
They may lose the protections.
Yeah, that's a principle.
So that's why I'm saying you need to go to your landlord if you're facing difficulty under the newly agreed arrangement.
Okay. There's a series of questions which are quite similar, and some of them are asking questions, for example, that my landlord is a trustee of a super fund, or is in fact a large super fund.
They're Australian.
Or is a foreign national. Does the nature of the landlord change the application of the code or the New South Wales regulation?
I don't think it does. I don't think it does. It's all about what is an impacted lessee.
Right.
That's what it's about. It's about what's an impacted lessee and the definitions around that. Although I must say a super fund landlord has got other restraints on them to other legislation. And that's the subject of getting some pretty good accounting and tax advice as to what you can do as a super fund owner of land, of commercial land, in terms of a variation.
Jane, this one's for you. My tenant has now moved out 20 months, leaving 20 months still on the lease because they say they cannot recover from a business perspective. I rely on the rent to pay my mortgage, which is accruing at a particular amount. What should I do? So we've got what appears to be an abandoned lease. What are the rights of the landlord in those circumstances?
The landlords, well, the tenant's already moved out, so it's going to make it difficult to enter into a negotiation with them, although we don't know. I don't know. Look, Warwick, do you think that the lease would be found?
Look, that's a very case-specific type question, which needs an analysis of why the tenant abandoned the premises. Has the lease been terminated? Was the reason nothing to do with the pandemic? Was the tenant's business already not paying rent? Were they under default before the pandemic?
I think that's what it will come down to.
Yeah.
Have they abandoned the premises because of COVID-19? And if they have, then they're probably going to fall within the principles of the code.
Yeah. Don't forget, this code and the regulation is about varying existing leases into the future, not about ones that have been already terminated.
So if we just go back to first principles, the abandoned lease still would have a contract underlying it. And
Yes.
in ordinary circumstances, you would say that the landlord would consider whether they would sue on the contract for the rent that's
right.
foregone. But your answer seems to be, depending upon the nature of the tenant and whether they are appropriately an
Impacted lessee.
impacted lessee, certainly in New South Wales, then the prescribed actions regime would apply, I'd imagine.
That's right. Yeah, you've got to be an impacted lessee. The pandemic must have caused the problems that lessee faced. And if it didn't, then they don't come under the regulations.
So final question, we're running out of time. Does it make a difference for negotiation purposes if, for example, you had neighbouring tenancies? One was a business which was effectively closed down for 6 months because of the pandemic, and the neighbouring business which just decided that it wouldn't trade for the duration of the pandemic. How would a landlord deal with each of those? Identically, differently?
Well, once again, the law applies equally to both situations. Certainly the tenancy that had to close down because of the pandemic would be considered an impacted lessee.
Yep.
And there'd be requirements to negotiate in good faith in regards to variation. As to the other tenant, who may not have been impacted by the pandemic, they just decided to close down. Well, they've got to prove they were impacted by the pandemic. And they've got to show the landlord that's the case. And they've got to do that in good faith. You can't just say that. You've got to be able to prove it. Because a landlord can say to a tenant, you know, you've been breaching this for the last few years. That you're using this as an excuse to get out of a lease. And if the landlord can show that, well, the tenant might not be an impacted lessee. But it's a case-by-case situation.
Right. That's what it comes down to, is that tenant an impacted lessee? And I suspect that'll be the same across the nation.
I expect a lot of arguments around that because I do hear from landlords that some tenants have been breaching for years and they're just using this as an excuse to get out of a lease, which I don't think will be accepted. So, yeah, you have to be an impacted lessee. The pandemic must have affected.
So your advice in those circumstances to the landlord would be, whether it's a bad tenant being opportunistic, nonetheless, look to the code outside of New South Wales, look to the regulation in New South Wales.
Go through the machinations of negotiations in good faith, and then see if you can come to a solution.
Ladies and gentlemen, we've just run a little bit over time. Apologies for the technical difficulties earlier. Thank you very much for your time. We have some resources available. So if you look on that screen, you'll see there's a resources hub that our law firm has, and there's lots and lots of articles in and around the pandemic, property and otherwise. At the bottom, there's a click through. So if you follow that, that will take you straight to the New South Wales regulation, and we recommend wholeheartedly that you read that. For more information, you can see a contact website for ABLA. There will be emailed out to you an article on the New South Wales regulation. That will come out today, we think, or if not, it'll be tomorrow morning. And we'd be interested in your comments. If there's anything more we can do for you, we'd be delighted. Thank you very much for your time.